Good evening, everybody. My name is Eleanor Bertelson. I'm a family tenant at 42BR Barristers. I'm here this evening with Max Montgomery, and we are going to be speaking to you about parental responsibility, having it, acquiring it, removing it. So we're going to do a guide from the basics up to Jade's Law, which is probably the most recent development, certainly in terms of statute, in respect of losing parental responsibility. So this is the third webinar in our latest family law series. The previous two recordings can be found on our website, as well as the registration links for the remaining session, which is taking place on the 4th of December. So that's Wednesday of next week. Any questions that you have can go in the Q&A box, and they'll be addressed at the end of the session rather than as we're going along, depending on how we're doing for time. And if we run out of time, then we're going to follow up via email. If you are watching the recording, then please send any questions to events@42br.com. So parental responsibility, which is something which as family lawyers we deal with on a virtually daily basis, a concept which we think we know about. It turns out, certainly in my research, there were things I didn't realise were the case for parental responsibility. It's a concept which has obviously changed considerably over time. So if we take as an example Caroline Norton, a woman who was alive in the 19th century. She was a woman whose abusive husband abducted their 3 children shortly after she left him and hid them with relatives in Yorkshire and Scotland. The reason why her name is written in history is because as a result of her intervention and her campaigning, the Custody of Infants Act 1839 was passed in the UK, which is the first law in the UK to give women rights and respect of their children. And what it did was that it allowed women to petition the courts for custody of their children up to the age of 7 and to petition for access to older children. Clearly, things have changed somewhat since that time, which is what Max is going to be talking to us about a little bit. So going from the time when, in essence, women weren't really expected to have any responsibilities in respect to their children unless they were contingent on their husband, to what we can see now in the updated law of the 20th century, and particularly the Children Act of 1999.
Thank you, Eleanor, and hello, everyone. I will be dealing with the having parental responsibility and acquiring parental responsibility sections of this talk, and before I pass back to Eleanor to deal with the restrictions that can be put on it and indeed removing it. So firstly, what actually is parental responsibility? It's a legal relationship between a parent and a child, separate from the concept of parenthood itself. And the definition for it can be found within the Children Act 1989. And that is a piece of legislation with which you will no doubt be familiar. And it's one that I will be referring to throughout this talk. So if I just say a section, that is the piece of legislation that I'm referring to. And the definition we're looking for is in section 3 of the Act. And it says that parental responsibility means all the rights, duties, powers, responsibilities, and authority which by law a parent of a child has in relation to the child and his property. So we don't there have a particularly specific definition that is massively useful, if I may say. But what we do have is a substantial body of case law which has established the sort of decisions that those with parental responsibility are responsible for. So that includes the name of the child, their living arrangements, their religious beliefs, their education, the school they attend, consent for medical treatment, consent to taking the child abroad, although you may be familiar with an exception to that in section 13.1 of the Children Act, which gives those who have a lives with order in their favour authority to take the child away for up to 28 days without the consent of others with parental responsibility. So those are the sort of things it covers. And if we flick on, there is a recent case from just this year, re-EMP, a child re-section 8 of the Children Act of 1989, That was a case before His Honour Judge Baker. It was an application by a father for a spend times with order, and the mother in response applied for an order revoking the father's parental responsibility order. The mother made some very serious allegations against the father, and at a fact-finding hearing, it was established that the father had raped the mother. And the child of within the case wanted nothing to do with the father, and indeed, the judge went on to revoke the father's parental responsibility. But what I particularly want to focus on at this stage is how the judge defines parental responsibility. And what he did was embrace the definition that can be found with a simple Google on the gov.uk website. And what that says is that if you have parental responsibility, your most important roles are to provide a home for the child and protect and maintain the child. And you're also responsible for disciplining the child, choosing and providing for the child's education, agreeing to their medical treatment, naming them, and looking after the child's property. So a fairly simple and very useful definition there of parental responsibility. One other case, just to bring your attention to at this stage, is the case of A&A shared residence. That's a case from 2004 before the Honourable Mr. Justice Wall. Rather unusually, you may think it's not a case involving an application for a parental responsibility order or to revoke parental responsibility. It's a contact case. It was an application for shared residence. But it's interesting because it's noted that before there was a real breakdown in the relationship between the parties, they had been, things had been working, and they noted that they shared equal parental responsibility, and they'd actually produced a schedule of items in relation to the exercise of parental responsibility, and it identified 3 different categories. Now, the judge was rather impressed by this, and described it as an extremely useful document, and actually attached a copy to the judgment. Now, as you can see on screen, the 3 categories are decisions that can be taken independently and without any consultation to the other parent. So those are simple things such as how the child should spend their time during contact. The second category was where one parent would need to inform the other parents, but not necessarily consult and take their views into consideration. That was booking holidays or things like medical treatment in an emergency. And then the third category of the exercise of PR was decisions that the parent would need to inform and consult the other parent on before making. So that's more significant decisions, the school that the child was to attend, stopping any prescribed medication, and so on. And so that's a useful illustration of how parental responsibility can be exercised, and it's worth digging out that judgment to have a look at that schedule. So how can parental responsibility actually be enforced? Well, this is what gives the concept its teeth. Parental responsibility can be enforced through Section 8 of the Children Act, either by a prohibited steps order restricting its use, or a specific issue order, which is enforcing and exercising its use. The definitions of those 2 concepts within Section 8 do actually refer to parental responsibility explicitly. So a prohibited steps order is defined as an order that no step which could be taken by a parent in meeting his parental responsibility for a child, and which is of a kind specified in the order, shall be taken by any person without the consent of the court. A specific issue order, on the other side of the coin, is an order giving directions for the purpose of determining a specific question which has arisen or which may arise in connection with any aspect of parental responsibility for a child. The classic examples often which school the child goes to, where they live, and so on. And so that's how it can be enforced. Of course, children are often cared for by those who don't actually have parental responsibility, and there is a limit to the power and essentially the control that those people can have over children. That limit is found within Section 3.5, which states that a person who does not have parental responsibility for a particular child but has care of the child may, subject to the provisions of the Act, do what is reasonable in all the circumstances of the case for the purpose of safeguarding or promoting the child's welfare. And that was clarified in the case of S, Abduction, Hague and European Conventions, which I've put up on the screen. And that says that the control over the child for those without parental responsibility is restricted to the minimum necessary to provide for the day-to-day welfare of the child. So really is rather limited without parental responsibility. So turning then to who actually has it. And there are a few different categories here. I've set out the relevant provisions on the slide. I won't go into them in detail, other than to note that the categories are biological mothers, fathers, either those married to the mother or in a civil partnership with them at birth, or indeed named in the birth certificate, and similarly second mothers who are married or in a civil partnership with the mother at the point of conception, or indeed named in the birth certificate. And then otherwise, it's those who come to acquire it. And that's where step parents come in particularly to the equation. So if we consider acquiring parental responsibility, what I really want to focus on before I hand back to Eleanor is parental responsibility orders. But in fact, there are also a number of other ways that someone can acquire parental responsibility, and I'll touch on those first. So firstly, we have adoption. So section 46(1) of the Adoption and Children Act 2002 provides that the adopter acquires parental responsibility. And indeed, actually similar to that is a parental order, also under a separate legislative provision, which I can come back to. And similarly, on a child arrangements order under section 8 of the Children Act. And there is a distinction here between the sort of order that is made. So if a lives with order is made, parental responsibility is automatically acquired. And that's either a father or second mother under section 12(1), or indeed a non-parent or guardian. So that is where, and that's under section 12(2), that's where a step parent often comes into the equation. And parental responsibility is automatic in those situations. If instead it's just to spend time with order that is ordered, the court has a discretion and will decide whether it's appropriate to grant a parental responsibility order, and that's pursuant to section 12(1)(a). A couple of other points to touch on briefly. If a guardian is appointed under section 5, that's someone who will acquire responsibility or have responsibility for a child upon the death of those with parental responsibility. Section 5(6) says that upon that death, that person, the guardian, will acquire parental responsibility. And similarly, section 14(c), where a special guardianship order is made for the duration of that order, the special guardian shall have parental responsibility. And final one then, before parental responsibility orders, is a parental responsibility agreement. Now, this, contrasting to parental responsibility orders, is essentially where everyone agrees. So where fathers, second mothers, or step parents are to acquire parental responsibility, and others who have parental responsibility consent to that process, well, then they can fill in a form, which has to be in a prescribed form. The information on that, on the prescribed form, can be found at that link on the screen. Essentially, it must be signed, witnessed at court. There are certain documents, including the child's birth certificate, that have to be provided along with it. And provided that's done, everyone can agree for parental responsibility to be acquired. And that can be contrasted with an application for a parental responsibility order, which is where, and I suspect this is what you may be more familiar with, where everyone doesn't quite agree to what should happen. So three different categories again here for parental responsibility orders. Firstly, in relation to fathers. So section 4 of the Children Act deals with fathers, and section 4(1) sets out the three circumstances in which a father can acquire parental responsibility. And we've already touched on a couple. So it's A, where they become registered on the birth certificate, B, through a parental responsibility agreement, or C, by a parental responsibility order. Now, those provisions are reflected for second mothers in section 4ZA, 1 to C, again, birth certificate, parental responsibility agreement, parental responsibility order. And then for step parents, essentially the same, but without the ability to be registered on the birth certificate. So just an agreement or an order. What none of those provisions provides is a test. And so we have to turn to the case law to figure out the test for parental responsibility orders. And helpfully, There is a substantial body of case on that, and a fairly firm test has been developed. So the key case is Re H. Minor's Local Authority Parental Rights number 3 from 1991, and that established a threefold test. And I've put that on the screen. So that is, firstly, the degree of commitment which the father has shown towards the child, and indeed the same applies for second mothers or step-parents. Secondly, the degree of attachment which exists between that party and the child. And thirdly, the reasons of that party for applying for the order.
I'm actually just going to pause there for a moment. You will notice that in the early cases, it's always cited as the father rather than person wanting to acquire parental responsibility. It's a bit retro, but look at the date on which that case was decided. It was 1991. So just a couple of years after the inception of the Children Act, clearly things have moved on quite a lot, even within our lifetime.
Absolutely. And that's something actually which a case I'm about to look at reflects a touch. What has happened, though, in the development of the case law is that while this three-stage test is applicable, what the Court of Appeal said in 2012 in A v. B and C, lesbian co-parents, role of father, was in the end, the only principle is the paramountcy of the child welfare. And as these things often come down to under the Children Act, that is the crucial principle that the court is applying, and it will take into consideration those three stages of the test in doing that. One important thing to note, actually, is that the welfare checklist does not explicitly apply to applications for a parental responsibility order, and so that's the language of that test won't be used within judgment. So one case to bring your attention to demonstrate some interesting points about parental responsibility orders, and that's the case you can see on screen of D, contacts and parental responsibility, lesbian mothers, unknown father. And that was a case before Mrs. Justice Black in 2006. And so actually, when you read the judgment in that case, you really can see some shift in society's view. But we really have moved on from there. Much of this case was about how society would view two mothers and one child. A brief factual background to that case. This was two long-term female partners who wanted a child. They advertised for a man to father the child. So crucially, that's the way they went about it, rather than sort of illegal sperm donation.
Unregulated.
Unregulated, indeed. And what they said explicitly at the time was they wanted the child to have a father figure in its life, in his or her life. The man conceived a child with one of the mothers through a natural conception. And unfortunately, what the parties hadn't done before the child was born was set firm guidelines as to the level of involvement between the man and the two mothers. Somewhat predictably, the father wanted a greater level of involvement in the child's life than the two mothers wanted. And while they were willing for him to have some involvement, it led to contact proceedings early in the child's life. The father was given contact once a month, and that actually increased. By the time we get to this case, that had increased to fortnightly contact. The father then applied for a parental responsibility order, which the mothers opposed, as they didn't want him to be recognised legally as the child's father, and they were concerned about how society would look upon that, given the nature of their relationship. And it's worth noting at this stage, this was only 2 years after the Civil Partnership Act, before gay marriage. It was at a time when society's view of gay relationships was rather different to what it now is. The court had the benefit of expert evidence in the case of a consultant child and adolescent psychiatrist. And that, again, makes for really interesting reading. And I've set out the paragraphs where that can be found. Particular points to draw your attention to in terms of the expert evidence. The psychiatrist found that, in her view, the parental responsibility issue did not have significant importance for the child, and rather what was important was contact and knowledge of the father. And she goes on, this is paragraph 75. The parental responsibility question revolves around the integrity and stability of the family, This in turn will determine the child's stability and security and ultimately happiness. Talks about the issue of the father wanting some level of visibility in the life of the child, but the mother's opposing that. And what the psychiatrist said was that what would solve this is paragraph 83, what would solve this would be if the father could receive official recognition in some way, but not be allowed to involve himself in the nitty-gritty of the child's life. Now, the expert ultimately determined, they said it was finely balanced, but they didn't see any direct benefits to the child of the father having parental responsibility, but that the visibility would give the child some tension. The judge disagreed and came down on the other side and adopted essentially the expert's suggestion of preventing involvement in the nitty-gritty of the child's life. And there's an interesting discussion at paragraph 89 of the judgment, where one interesting line from the judge is that perhaps most importantly of all, I'm considerably influenced by the reality that the father, Mr. B, as he's known in the case, is the child's father. And for that and other reasons, the judge decided to make a parental responsibility order, but limited the contact that the father would have with the children. And the father had actually said in evidence he would be willing to agree to a prohibited steps order, that he wouldn't be able to take certain steps that the mothers had complained about in the past. So that included contacting the child's school or indeed medical professionals. And in the end, rather than make a prohibited steps order, recitals were agreed on that front. So what we see there is the court showing the importance of a parent in a child's life and of having parental responsibility, and indeed how that can be regulated. And so one final case then to draw your attention to before I hand back to Eleanor, going back to re-EMP, which I touched on earlier, the case from this year. Now, this is in relation to revoking parental responsibility. It's setting out the options that a court has. And you see there, it's leaving parental responsibility unfettered, leaving it but regulating it with a specific issue or prohibited steps order, or indeed revoking it. And I wanted to bring this up to show that in fact it's the same in terms of an application for a parental responsibility order. The court has the option to make that order, but can regulate the exercise of it by a specific issue or a prohibited steps order. So I think that's an appropriate bridge to hand back to you, Eleanor, to deal with revoking and indeed restricting parental responsibility.
So removing parental responsibility. This is in some respects a slightly misleading title because it falls onto two slightly separate categories. Parental responsibility can't be terminated for everybody who's got parental responsibility, but it can be restricted and it can be set to almost naught. And really, which route you might want to go down depends on how parental responsibility was acquired in the first place. So this is why anybody who is watching this talk and is faced with this difficulty, go back to the first few slides that Max showed you about how parental responsibility was acquired, because that is going to be your guide light to what remedies might be available one way or the other. So there are certain persons who cannot have their parental responsibility terminated except in very specific circumstances. So there are mothers and then persons who acquired parental responsibility by virtue of marriage or civil partnership to the child's mother. So that's regardless of whether or not that other person is a man or a woman. There are, of course, ways in which their parental responsibility can be restricted in various ways, short of rendering it almost meaningless. And that is by the making of specific issue and prohibited steps orders. If there's some particular step that a parent wants to be enabled to do, or you want another parent to be prevented from having a role in, special guardianship orders, which of course very significantly restrict how a parent is able to exercise their parental responsibility in relation to a child who is subject to that order, because of course the special guardians have got parental responsibility which they're able to exercise to the exclusion of parents or other persons holding PR prior to making that order. And of course also where there is a care order, where a local authority shares parental responsibility, because the regulation of how PR is exercised is the subject of various extremely interesting regulatory schemes, which some of you, of course, may be very familiar with. But that's not really what we want to talk about in this talk. We want to talk about the nuclear option. So where persons have acquired their parental responsibility by virtue of a court order, then it can also be terminated by way of a court order. And that is terminated rather than diminished. So I did mention before that there were certain circumstances where mothers and spouses could have their parental responsibility extinguished. And that is only in really two circumstances. So the first is an adoption order, and the second is the making of a parental order, because that has the impact of extinguishing parental responsibility and indeed status as legal parent. Those two things, of course, not being the same, parenthood being separate to having parental responsibility, as I think Max demonstrated earlier on. So for mothers and spouses, they can have the exercise of their parental responsibility restricted to almost nothing by way of court orders. And we're going to look at that now. So we're going to look at the case of B and C, which concerned three basic issues. So the change of names, parental responsibility, and the evidence that would be that a parent can see in such an application. This was a decision by Mr. Justice Cobb, which was delivered in 2017. And I'm going to start by telling you what the end point of that was. The judge made an order which prevented the father from taking any steps in the exercise of his parental responsibility in relation to either of the subject children until they reached the age of 18, or until the court made a further order. The court held that these kinds of orders are draconian and rare, but in this particular case, it was necessary and proportionate in circumstances where the father had abducted the children to Iran. And I'm going to go through some of the facts now. The starting point is that the parents were married. They were Iranian. They moved to the UK in 2003. In due course, they had children who were aged 13 and 8 at the time of the judgment. And just in terms of what had happened, because the facts are relevant to how the court then went about making its decision, the mother claimed in the course of her application that the relationship with the father had been abusive pretty much from the outset. He was intimidating and bullying both towards her and also towards the children. There was evidence that the police had been involved, that they'd attended on numerous occasions. And in fact, the mother and the children had spent time in a refuge on at least 2 separate occasions, but on each occasion had returned to the father. In 2014, the whole family went to Iran, and there was some ambiguity as to whether or not that was because the father had promised the mother that he would agree to a divorce in the event that they were to go there on holiday. But whatever it was, they weren't reconciled. And what happened when they got there was that the father removed the children from the mother's care and tried to prevent her from leaving the country. On that occasion, she escaped with the children. And when she returned, she applied for injunctive orders under the Family Law Act. And eventually she obtained a non-molestation order. So the father issued an application for a child arrangements order, and he obtained an order which said that the children could spend a couple of nights with him each week. Can I just first of all say, these are not the applications which are the subject of his decisions, because there were 2 sets of proceedings. In addition to that child arrangements order, there's a prohibited steps order, which prevented him from removing the children from the jurisdiction. But in fact, the abuse continued, handovers and so on. And in 2017, the father abducted the children to Iran via a circuitous route, and they remained in Iran for 7 months. And eventually the mother was able to retrieve them by effectively re-abducting them from them and travelling back to the UK in part overland, assisted by various UK government agencies and the UK embassy in Turkey in order to get the children back to this jurisdiction. When she came back, of course, she applied for a number of orders. She applied for an order to change the children's surnames, but also their given names. She applied for a specific issue order, which limited how the father could exercise his parental responsibility. And in due course, the court made the orders that I previously described, effectively emptying out, as it were, the various rights and responsibilities that the father had in respect to the children, other than his ability to, at some point in the future, restore the matter back to court. How did the court go about making this order? Well, it was able to make the order because effectively there was solid and secure evidence and a solid and secure factual basis for the making of that order or those orders. And the court was satisfied with regard to the children's welfare that it was better for them for such restrictions to be put into place than for those orders not to be made. It was satisfied that the children were extremely fearful of their father. They were likely to experience emotional trauma if they believed that he even had access to information about where they were living. And it really brings to mind this question, how significant is parental responsibility in those circumstances, and why is it that it can't just be terminated? How bad do things have to be in order for a father who happens to be married for his parental responsibility simply to disappear? Well, the short point is it can't, but what you can do is that you can restrict the parental responsibility to a point where effectively it is meaningless. That case does contain a distillation of the case law. It's a very useful case, which I would encourage you to look at. And it sets out a number of expositions about what parental responsibility is and the significance of the orders that were sought by the mother. The court considered that they were both far-reaching and exceptional, because what she was trying to do by her applications, the mother, was to disenfranchise the father in practice as a holder of parental responsibility for the children, and to create for the children wholly new identities, which were deliberately to be kept secret from him. So it's quite an extreme example. Again, the orders could only be made because there was a solid and secure evidential basis for doing so, and the orders were palpably in the best interests of the children concerned. The court also considered the impact on the children of effectively severing them from their past by the changing of their surnames and their forenames, which was not considered to be not a trivial matter. And again, it could be seen as deliberately expunging traces of their father's familial line. And this is where we get into where the family court really looks at the, shall we say, more philosophical ideas behind what it really means to be a parent. The court also cited this, which is derived from the line of case law relating to changes of names and surnames. And a surname is described as a biological label which tells the world at large that the blood of the name flows in its veins, which, again, I think I mentioned before that some of the language that you see in some of the case law may seem somewhat antiquated, but really this is what it boils down to. It is to do with really important concepts of identity, which can only really be analysed via the prism of the child's welfare. So in the same case, the court actually noted that it wasn't possible to revoke or withdraw the father's parental responsibility, but that in exceptional circumstances, the court did have the power to restrict it by means of a prohibited steps order. Just by way of a coda to that decision, where the court decided that clearly the remedy was necessary and proportionate to achieve the objective of ensuring the welfare of the mother and the children, especially their safety and their emotional and their physical well-being. The court did cite quite an unusual case, which I'm just going to touch on briefly, which is this case, Reby adoption natural parent. And I'm just throwing this in here really because it illustrates, I think, sometimes the absurdity that we reach in family cases and the sort of new scenarios that come up, which you think, gosh, how was that ever even possible? Well, Reby, it's a decision which is now, I'm alarmed to see, 23 years old, but it is fairly extraordinary. It comes with a bit of a health warning because it's a decision that was made prior to the Adoption and Children Act 2002, and also prior to decisions in a line of cases regarding placement orders and the circumstances in which they should be made, as well as adoption orders and when they can be made. But this is a case which involved a child whose parents separated before the mother realised that she was pregnant. She went on to give birth. She didn't tell the father that she had had that child. And the father found out that he'd had a baby by happenstance when the local authority got in touch with him, and he expressed a wish to care for the baby himself. The parents entered into a parental responsibility agreement, and the mother at that point abandoned the idea of the child being adopted. And the child went to live with the father and had no contact whatsoever with the mother. And about 2.5 years later, the father applied for an adoption order for him as a sole adopter. And of course, the effect of that would be to bring an end to the mother's parental responsibility. And the mother didn't oppose it. The reason why it went as high as the Supreme Court is because the official solicitor got involved in the case and intervened, opposing the application, effectively for policy considerations. But the official solicitor was ultimately unsuccessful in overturning the adoption order that was made at first instance. And this is, as I say, quite an unusual case. One Andrew McFarlane QC leading, one David Hirschman represented the father, two names which I'm sure will be very familiar to you. And the House of Lords held that in the circumstances where it was in the child's best interest to make an adoption order in favour of one natural parent alone, this was likely to be exceptional. And in this case, the reasons justifying the exclusion of a natural parent had to be sufficient to outweigh the adverse consequences that such an exclusion would have on the child's life. Adoption in this instance was in the child's best interests, given the father's anxiety about the mother's continuing status as a parent with parental responsibility, which could potentially affect the child's stability. And the mother also consented to adoption being in the child's best interests. So an unusual case, but quite an interesting one, one which I think also illustrates how the various aspects of the law run in tandem and how they can change over time. And one wonders whether that case, if heard today, would be decided in the same way, or even if it would go as far as it did way back then. So I would like to turn to another aspect of this, is what do you do if you're not married? And what does it take for parental responsibility to be ended in those circumstances? So this is only possible in the case of a person who's not married or in a civil partnership with a child's mother. And the case which I'm going to take you to is a case called Reedy that was decided by the Court of Appeal in 2014. The principles were also distilled in the case that I've just previously cited, so the case of B and C, which is the one to do with the change of names, parental responsibility and evidence, which obviously looks at the scenario in respect of married parents. And in essence, the test for the two is the same. So as I said, this case concerned unmarried parents where the father had parental responsibility by virtue of being named on the child D's birth certificate. And D was 5 years old when his father pleaded guilty to sexual offences committed against the mother's two daughters from a previous relationship. What's not clear from the judgment is whether they were children at the time that the offences were committed, whether they were adults. But whatever the case may be, the father was sentenced to 2 years imprisonment. When he was released, the mother applied for an order terminating his parental responsibility. And the father applied for a specific issue order, which would have required the mother to provide him with annual reports on his son's progress. And he said that he did not intend to seek any order, any Section 8 order over and above this specific issue order. He hadn't seen D since he was 4 years old. And at first instance, Mr. Justice Baker made an order removing his parental responsibility. And he appealed to the Court of Appeal, who dismissed his appeal. So looking then at what the Court of Appeal said, first of all, there was an exposition of parental responsibility as an important status, an incident to the family and private lives of the adults and child concerned, which reflect the way in which parents should exercise their responsibilities for their child. And it should be rare for a father not to be afforded that status. Second, the court considered that parental responsibility is something which describes an adult's responsibility to secure the welfare of their child, and it's to be exercised for the benefit of the child and not the adult. And the status relates to welfare, not just paternity or fatherhood, which goes back to your sperm donor case. Yeah. So third, when considering the cessation of parental responsibility, the court is considering a question with respect to the upbringing of a child, and the paramountcy principle in section 1 of the Children Act 1989 applies. So again, that illustrates pretty much the red line throughout this talk, which is that is what you need to go back to. The Court of Appeal went on to say that by section 1.4 of the Children Act, there's no requirement on the court to consider the factors in the welfare checklist, but the court isn't prevented from doing so. And in fact, the court said that it may find it helpful to use an analytical framework such as the welfare checklist, not least because welfare has to be considered and reasoned when making such a decision about parental responsibility. The no order principle applies. I pause here just to say, if you think that this is quite a long list, you are going to get all of this in the longer slides that we'll be sending to you when this talk is finished. So if you're making notes, please don't worry, you will have this in writing. So I go back to number 5, the no order principle applies. That's to say that the court has to consider whether making an order bringing parental responsibility to an end is better for the child than making no order at all. And the factors relevant to the court's consideration of the grant of parental responsibility. So this is going back to what Max was talking about earlier. So the degree of commitment which the father has shown or a parent has shown to the child, the degree of attachment which exists between a person who has parental responsibility and the child, and the reasons of that person for applying for the order may be relevant at the point of considering whether to revoke or limit the exercise of parental responsibility. A child would ordinarily benefit from a relationship with both parents, but this is clearly not the only aspect of the case that the court needs to look at. Parental responsibility, which attaches to parenthood, may bring an added commitment to the child, which would be likely to be to the child's benefit. And finally, in this exposition of what parental responsibility it means within this judgment, the court added that a significant matter of status as between parent and child, and just as important as between each parent, by stressing the responsibility, which is so clearly given prominence in section 3 of the 1989 Act, and the likely circumstance that that responsibility is shared with the other parent. It's hoped that some parents may be encouraged more readily to engage with the difficulties that undoubtedly arise when contemplating post-separation contact than may hitherto have been the case. In my view, I'd say that's optimistic, because the fact that it's set out in the Children Act doesn't prevent parents who make applications to the court from seeing their parental responsibility as a set of rights that they have over a child, rather than a bundle of rights and duties which need to be negotiated with the other holders of parental responsibility. Of course, the final coda to that is that Article 8 is engaged in respect of all family members, and interference with those rights need to be justified. So those are a checklist of things to be considered when looking at the termination of parental responsibility. The guidelines, of course, are looking at this through the prism of what is in the child's best interests, that being the most useful analytical tool, and not underestimating the importance to children of parental responsibility and their parenthood. I want to go on to discuss another case which is more recent. So let me just see if the clicker is working. Yeah. So pressing the fast forward button a few years and going on to 2021. So decided 7 years after the case of Reedy withdrawal of parental responsibility. And this is a case again where the parents weren't married. They were separated in 2014, so actually around about the time of the previous decision that I was discussing. And at that point, the child was only 16 months old and the father was named on the birth certificate. He applied for a child arrangements order permitting him to spend some time with his child. The mother alleged domestic abuse and no findings were made. This is when the child was a baby. And a final order was made for unsupervised contact. The father had a significant offending history, which was examined by the court when it came before it in 2021. And that included harassment of the mother and wounding with intent. And he was also being investigated for sexual offences against a child. On the advice of the police and social services, the mother actually stopped contact and she moved away. In 2016, the father was convicted of sexual offences against a child, and he subsequently went on to breach his sexual harm prevention order. And in 2019, he was sent to prison again because he placed an advert on social media advertising for someone to harm one of his ex-partners. By the time the case came to court in 2021, the child was separately represented, and the Guardian recommended that the previous order, which permitted contact, should be discharged, but actually went considerably further than that and went on to say there should be no contact, the child's surname should be changed and the father's parental responsibility should be terminated, and also a section 9114 order should be made, which effectively would have compelled the father to apply for leave to make any further applications in respect of his child. In that case, the court determined all the applications in the mother's favour such that the child arrangements order was discharged, there should be no contact, and the child's surname was changed in the child's best interests. And in addition to that, the court terminated the father's parental responsibility, considering that the child's welfare was the court's paramount consideration. The very lucid exposition of the law in that case is really a joy to read. I know that many of you probably aren't very keen on reading cases. I would really recommend that you read this one because of how clearly it is set out. In effect, what the judge in that case did was to say that the court has to ask itself whether, if the father were applying for an order conferring parental responsibility on him now, would that application be granted? And the court has to consider again the evidence of attachment and the degree of commitment, concepts that we've touched on previously, and the presumption being that all things being equal, a parental responsibility should be made rather than withheld in an appropriate case. In this case, however, the court was entirely satisfied that there was no evidence of attachment because his father hadn't seen his child for actually a significant period of time by this point. And in addition to that, the father hadn't demonstrated the level of commitment that would support the making of a parental responsibility order. And I pause here to note that we've all done cases where we wonder, but why is this person pursuing this application? Because they haven't done any of the things that the court has asked them to do. They have argued every single point. They haven't filed any statements. Why are we still here? Well, actually, that weighed in the balance at the conclusion of this case, because this father had done absolutely nothing. He didn't turn up to the final hearing, and the case was actually determined in his absence, the court being satisfied that there was sufficient evidence before it for those orders to be made. One of the concerns that the court had was that if the parental responsibility was not terminated, there was a significant risk that the father would continue to use parental responsibility to control the mother in some way. The court also granted a section 9114 order, so what's sometimes known as a barring order, preventing the father from making further applications without leave of the court. And that was notwithstanding the fact that there wasn't a history of making unreasonable applications. But the court made it nonetheless because the absence of the order would place the child and the primary carer under unacceptable strain. And the order was made until the child was 16. So I think that that is a short exposition of how it is possible to press the nuclear button and completely bring to an end or render to almost nothing a parent's exercise of parental responsibility. I'm just going to touch very briefly on whether the law is discriminatory to unmarried persons with parental responsibility, because I've noticed that we're slightly running out of time. But I'm going to refer you to two cases. The first, which is on the screen, is the case of Smallwood versus the United Kingdom. And that has been argued more fully, more recently in the Court of Appeal in the case of Re A Parental Responsibility 2024 at 1 FLR 1 being the citation. The neutral citation is 2023 EWC A Civ 689, where where the point was fully argued as to whether or not it was discriminatory. The short point is that it isn't. The European courts do not consider it to be discriminatory. It is within the margin of appreciation for the court to determine, the UK court to determine that it isn't discriminatory. I think that that's as much as I'm going to say about that now, because I want to talk about something which is, I think, of more significance, which is legal reform. And I've subtitled this Restricting Parental Responsibility, where somebody has been a really terrible parent. And I've cited there two laws, one which has been passed but which isn't enforced yet, and the second, the amendments to the Criminal Justice Bill, proposals for laws which I think may be quite interesting, and I bracket it as watch this space. So discussing first of all Jade's Law, this nickname for the law was named for Jade Ward, and she was a young woman who was murdered by her estranged husband, Russell Marsh, whilst their 4 children slept in her home. Marsh was described by the judge in his sentencing remarks as consumed with self-pity and jealousy, controlling and possessive, and in fact he was sentenced to 25 years in prison. So the idea behind this law was that bereaved family wouldn't have to make an application to have a parent's parental responsibility terminated or restricted, but the restriction should apply automatically in certain cases, and it wouldn't prevent an application for contact, but certainly it would mean that any survivors would not have to consult with somebody who was responsible for the death, one parent being responsible for the death of the other parent. So this resulted in amendments to the Victims and Prisoners Bill, which provides for the suspension of a parent's parental responsibility where they're convicted of murder or manslaughter in some cases of their child's other parent. And the provisions are contained at Section 18 of the Victims and Prisoners Act 2024, which I have up on the screen. So they're not enforced yet. They'll come into force when the Secretary of State appoints a date by means of regulations, and we obviously have a very new government with different priorities at the moment, so we can only hope that it comes into law soon. But just to explain what Section 18 does, it provides for the Crown Court to make a prohibited steps order where a child has 2 parents, at least one of whom has parental responsibility, and the parent who has parental responsibility for the child is convicted of the murder or manslaughter in circumstances where the manslaughter would be murder, but for a loss of control or diminished responsibility. The prohibited steps order must specify that no step of any kind which could be taken by a parent in meeting their PR for a child may be taken by an offender without the consent of the High Court or the Family Court, and it shall have effect until varied or discharged by the High Court or the Family Court. And there are exceptions to this, which is where, in effect, there are already orders in place made by the Family Court which meet the requirements required by Section 18. So effectively, you don't have 2 orders doing the same thing, you only have one. But it's quite interesting because it's importing into the Crown Court responsibilities in respect of children, which shades into the jurisdiction of the Family Court. And it's quite interesting, really, because the Crown Court can make an order or can refuse to make an order if it's in the interests of justice to do so. And it's quite interesting because one wonders, well, what are the interests of justice in this case? Will the interests of the child prevail, or will the rights of the parent responsible for the death of the other parent prevail? What training will be offered to Crown Court judges making this decision? And will it be part of the sentencing process? Are you going to have CAFCAS officers doing joint work with the probation service? Are we going to see two different services, which used to be part of the same organisation a long time ago, converge into the same organisation again. So there's lots about the detail of this, which is unclear, but it definitely is a watch this space, because really we're just waiting for a date for it to come into force. The next point that I wanted to discuss is just briefly the amendments to the Criminal Justice Bill that were moved on the 10th of May 2024. And this bill didn't enter the statutes books because, as we know, Parliament was dissolved in May of 2024 ahead of the general election. We now have a new government, and this has just fallen into desuetude. But I wonder whether or not this aspect of it may be resurrected in some way and introduced at another opportunity. So the effect of these amendments would have been to add a clause providing for the removal of parental responsibility for men convicted of sexual offences against children, where a person A has been found guilty of a serious sexual offence involving or relating to a child or children, and A had parental responsibility for a child or children at the time at which the offence was committed. In those circumstances, A ceases to have parental responsibility for all children for a time specified by the sentencing court, or until an application by A to the family court has been made to reinstate parental responsibility, and that has been approved. So a number of things which are interesting about this. It only applies to men. It only applies to men who've been convicted of serious sexual offences against children, so not women offenders. It doesn't define what amounts to a serious sexual offence against a child. One can pose the question, when is a sexual offence against a child not a serious offence? It doesn't specify who's to make the order. It doesn't say what removal means. And as we've previously explained, there's clearly a difference between removal in circumstances where you're married and where you're unmarried, and whether what you're looking at is an order basically removing all of your rights and allowing you the possibility of coming back to the court for a review, or terminating your rights completely in the event that you're an unmarried person with parental responsibility. But there's no allusion to that. And it also doesn't specify who's to make the order. So is it going to be the family court? Is it going to be the criminal court? It doesn't say. And it also doesn't contemplate the situation where a married person convicted of a serious sexual offence against children comes to father another child. What do they do then? Do they preemptively apply to a court to have their PR stated because they've seen the error of their ways? Do they apply after the child has been born? What are the rights of the children in either case? It's not clear. It seems a little bit crude. That is, however, an amendment which has been moved by a remarkable array of quite prominent MPs. And so I do wonder whether or not this is something that we will need to look again at some point in the not too distant future, but possibly in a slightly less discriminatory manner, because it now very firmly points the finger at men in a way which I don't think is going to be permissible. So that is a very quick canter through parental responsibility, how we have it, how we acquire it, how we lose it, or how you can certainly be slowed down in the exercise of it. We have gone rather longer than we thought, but we're going to wait for a couple of minutes just to see if anybody's got any questions. I think we've had one.
We've had, yes, a couple come through that I think we can deal with pretty quickly. One being, what is the difference between terminated and extinguished? I think that's just a linguistic.
Yeah, I mean, it's interesting because if you look at the subtitles of some of the cases, they're often quite different. And even if you look at the head notes of some of the cases, if you look at the online legal libraries, a lot of the terms are used interchangeably. But terminated, extinguished means effectively that there is no parental responsibility there at all, rather than it simply being reduced. But yeah,
yes, and I haven't seen separate definitions for the two of them. We also got a scenario put to us, which I think we can answer pretty quickly. So it's rather long. It says, where an individual is not a step parent, but an ex-boyfriend of the mother, named on the birth certificate and has been involved in the child's life since birth, child now 4 years old, and a recent DNA test has shown that this biological father is in fact not the biological father. So essentially, what options are available to him now going forward? And I think
I've done a case like that.
really,
Yeah.
well, I think the answer is perhaps in Re D that you were talking about,
Yeah.
where I think one of the lines you used was that the focus was on welfare, not biology.
Yeah.
And it's the same thing here. So this is someone who has parental responsibility. They're named on the birth certificates. The options essentially are the same as they were before. And I think where he needs to go to find his options is Section 8 of the Children Act. And it sounds like what he wants is contact. So it's a Section 8 child arrangements order application is, I suspect, where he will need to go.
Yeah, I would have thought so. I mean, the distinction between step-parent and an ex-boyfriend named on a child's birth certificate, if that person has been involved in the child's life, I mean, I think it's semantics, really. It very much amounts to the same thing.
Yeah.
So a step-parent isn't somebody who necessarily is married to the person who's got
No, I think, yeah,
from a previous relationship. It just means somebody who's in a relationship with somebody who's got children from a previous relationship.
Exactly. I think the language of the statute is non-parent or guardian, as opposed to specifically step-parent.
In terms of the rationale for marriage father's parental responsibility being impossible to terminate, no matter how awful the conduct, whereas it can be terminated for an unmarried father, why does the law still treat married and unmarried fathers differently in this respect? Well, I'm going to refer you to the case which I cited very briefly just now, towards the end of my talk, the last case which I cited, which is Re A parental responsibility, the case that was decided in 2024. It is a very involved answer. I think it's slightly outside of the scope of this discussion. It is an interesting point, but effectively what it boils down to is policy considerations which are considered not to be discriminatory as to the difference in status accorded in law between married people and people who acquire parental responsibility effectively by statute and by making an application. It is a very chunky judgment. It is 106 paragraphs long. That's a substantive judgment of the lead judge, who was, of course, Andrew McFarlane. So if you want the detailed exposition, I would direct you to that, because it really explains all the reasons why. But as I say, it boils down to the short point of policy considerations not being in any conflict with human rights considerations and the balancing of those different matters. I think we had one more question. It was sent really weirdly early on in our talk. I'm just going to see if I can find it. It was a question about the your sperm donor case.
Yes. Yes, we had a question come through, which was, does a legal sperm donor acquire parental responsibility? And I think what we are getting at there is distinguishing someone who has donated their sperm through a legal clinic. So that's one licensed by the Human Fertilisation and Embryology Authority. And that being quite different to the case that I was describing, where essentially it was an informal relationship with a couple and someone coming in to, in essence, donate their sperm, but not actually be a sperm donor. And it was an element of that case that the father took issue with the term sperm donor, and the judge said it was reasonable for him to do so. The short answer is it is quite different. There are protections for those under the Human Fertilisation and Embryology Act 2008, and those who donate sperm or eggs do not become legal parents. I can get in touch with the person who asked this question and find the specific provision within that act for you. But essentially that is quite different to the more casual setup, shall we say, that there was in the case that I was describing earlier, where the door is left open for an application to be made for parental responsibility.
So I think that that brings the talk to very nearly its conclusion. Just by way of a final remark, don't despair if you've got a client saying, please, 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 can you just make this stop? There might well be avenues. If you've got somebody who's really despairing because somebody is trying to exercise parental responsibility and they are just in a really terrible situation. We've all come across cases like that. The law does offer protections, and terminating parental responsibility, or at least restricting it to an almost meaningless term, is possible in the right case. Do you want to do the honours?
Absolutely.
Yeah.
Yes, thank you everyone for attending. That will wrap us up. If you are watching the recording of this and you have any questions, then please email them through to events@42br.com. That recording will be available shortly, and we would be very grateful for any feedback that you may have. The fourth and final session of this webinar series will be taking place next Wednesday, the 4th of December, and that is where Hannah Justiva and Catherine Hiles will be discussing enforcement of orders made in financial remedy proceedings. So they will see you then, and thank you very much for attending this webinar. Thank you.
Thank you very much.